Welcome back to the 7th session, the role of women in public law in the modern age. We do apologize to the presenters from this session. We have to make a quick and slight change, and I would first give word to Vojteć Vrba. He asked if he could present first because he has an unexpected emergency at the university and has to leave fast. So I hope that's all right with the other presenters. And also Lucie and Mrázková unfortunately will not be able to present today, so our session is going to be somewhat shorter than we expected. So that being said, I would like to give word first to Vojteć Vrba from West Bohemian University Faculty of Law, who will present his paper on the topic of legal position of women in Czechoslovak Army Corps during and after the Second World War. You may begin. Do you maybe have a presentation?
Well, hello, and good afternoon to everyone. I've got my the PowerPoint presentation here. So if you can switch the controls, and I may upload it or share it with you.
Okay. Do you maybe have an option, or Nina has to give you? Nina probably has to give you. Okay.
Okay. Well, in the meantime, I would like to thank you whole Iustoria team for their attitude, wonderful attitude, because, well, we've got slight emergencies here in Pilsen in Western Bohemia with the whole e-learning system, and we've got an unexpected meeting up there at the university, so I have to be very brief and very fast in my presentation. But thank you all. And the second remark I would like to address in the beginning is that first, when we started to think about attending the Iustoria, we tried to talk with Mr. Novák, Jakub Novák, that he will be presenting his portion of legal position of women in Czechoslovak army, and he specializes in the First World War affairs. So he will present the position in a legion, in the Czechoslovak Legion in Russia, and then I will follow him. But the problem is that now these emergencies appeared. I will have to present first, so I hope that you will remember at least something from my presentation. I can screen with you already, so I will begin if I may.
Okay.
Okay, thank you. So if you can see my presentation here, yeah, I can begin now. So once again, good afternoon to everyone from Pilsen in Western Bohemia. I would like to talk about the legal position, which is something like a status, but in my mind, the status is something to have, and legal position is something that's determined by duties and rights one has. And that's the starting point of view, the starting paradigm I'm looking at this problematic with. It all has to start somewhere, and the best way to start is at the beginning. So we have to start before the Second World War. In the interwar republic, the First Republic, as we call it here in Czech Republic now, and the first military act that really defined the duties and rights of a soldier or a military man, serviceman, was the Military Act from the year 1920. There you could find the second paragraph, which in its original wording read something like this. The duty to serve, or the military duty, which really was two duties in one, but let's skip that. The military duty was general and common for everybody, and has to be executed in person and in accordance with the letter of this act. The problem is as the wording is, the general and common duty really is something that could be applied on women too. Regardless the gender, that everyone was a citizen of Czechoslovak Republic. But the plot twist came when we checked the commentary, or I checked the commentary, and there was this sentence: the former exceptions before the original enactment of the act were 1-year volunteers, holders of the hereditary homesteads, clerics, cleric candidates, and providers for families. So there really was no thought about women joining the army. That's really surprising, because, as Mr. Novák will tell you, there were women in the army. But this military act just really didn't count on women joining the army at all. This broad wording of the act was later novelized by military service regulations. That's this very long legal document here. It was a regulation of government. It was not a law. It was something below the law. And that defined the military service as a service that pertains only to men between certain years. So there were no women. The whole affair was healed when the novelization of the original act from 1920 came to force in 1927. And the change of the wording of the second paragraph was changed, that the duty is general and common for not everybody, but men between the 21st year of his age and I think 60 or 55. I'm not certain, but there were only men from 27th year or from year 1927. There was a way how to be a woman and how to join army of sorts. That was under the act on the defense of the state that really dealt with problems of state under the attack or under some kind of danger. And by wording of paragraph 66 and further, there was something called the auxiliary forces. These auxiliary forces were not restricted by gender. Everyone could be a part of an auxiliary force, but the engagement of these people was usually in some rather not typical activities for a soldier. An auxiliary man or woman should not usually fight, shoot, or die for his country or her country in the field, in the battlefield. But if they were present in the field, they were to be considered as armed forces in regard to their the authority that was respected to them. A major could give order to someone in auxiliary forces. Next, the war came, and these two acts really did not cover what was coming to Czechoslovakia, to Europe, to everything. As I've learned and as I researched and then learned, you can formulate two certain trends in coping with women in the army during the Second World War. The first one is I would call it the Western turn, the Western trend. In the West, the model for this trend was forces of the Great Britain and of the British Empire. It was not to be considered a woman as a soldier, but there was something as a auxiliary force. For example, the women auxiliary air force or women Royal Navy service, which a woman could join. These women usually did some work again that was not typical for a soldier, but the question of involving women in these affairs was really not about gender equality, but it was about having as many hands on deck for the war effort as could be found. For example, if you have seen the imitation game about Alan Turing, women who worked in Bletchley Park, they were the women auxiliary air force members usually. They worked in administration and such affairs. But I will get to that briefly. However, as the Western trend went this way, so there was the woman in the army was not equal to a man in the army, at least in that she had to serve in the battlefield or engage in the battle as such. On the Eastern Front, there really was no difference between a man and a woman. It was just he or she was just soldier for the cause. So you can find many Soviet sharpshooters, tankists, etc., etc. How this came to project on foreign representation of Czechoslovak cause was at first in the West, many women joined Women Auxiliary Air Force or some other auxiliary force. For example, here you can see Ida Marie Sudická-Šumová. She was a meteorologist. She dealt with weather predictions. And she served in Women Auxiliary Air Force, and this was really a trend that embraced the exile government headed by President Dr. Edvard Beneš in London. The exile government really did not want to involve women as a common soldier in the war effort, even if it was for the good of the republic, future republic, or at least the government in exile. Various on the Eastern Front as a representative of the second trend that was formed in the Soviet Union in the late 1941, but really the first people outside of a very narrow circle around General Ludvík Svoboda came in the early 1942. Dealt with these affairs very differently. General Ludvík Svoboda was former legionary, and he issued the order number 41, in which he really ordered to everyone that every woman serving in the corps is granted the rank of a private. It means that every woman that really joined the battalion or then the army corps was to be considered as a normal soldier with every duty and every right of a soldier as such. The most famous soldiers, women soldiers on the Eastern Front include, for example, here Valeria Wieniawska or Maria Jalková-Lastovecká, both excellent sharpshooters. It is told that Maria Jalková once nearly shot down a German Bf 109, and as such. Here you can see a photograph from roll call of the women portion of the battalion. Women are usually roll called as a separate group, but only roll called. They really served under the general headquarters as soldiers as should be. Let's return back into the West because the situation as war itself progressed, the situation became really loud and clear. A government should somehow deal with the issue of inequality or really legal issue of existence of women in the army itself. So the President Beneš enforced Presidential Decree number 5 in the year 1944. As for the position of women in Czechoslovak Army Corps, the decree was in effect retrospectively or retroactively from the 27th of September 1941, which was the date the Czechoslovakia really entered the war as another participant. Although the exile government existed long before and exile forces of Czechoslovakia. But from this date, the government was counted as a part of the war effort of the Allies. And the decree said that for the period of service of women fall under the authority of all military service, disciplinary and criminal regulations, similar to auxiliary forces persons according to paragraph 73 of the Act number blah blah blah. This is the act that I have shown you before. So the women should be counted as an auxiliary force, not a common soldier, an auxiliary force. This really did not age well because after the Second World War ended, many of the women tried to get pension or something of a benefit that was provided to soldiers that really fought for the Czechoslovakia. But they really were not counted as ones. They were in auxiliary forces and they were counted as soldiers only when they were deployed in the field, and nobody really counted in during the First Republic that a woman can be deployed on the field with a rifle to shoot Germans or enemies in the broad sense, yeah. But after the Second World War, the decree remained in force, and women who left the army did not retain their status. So you either had to serve in the army after the Second World War, and when you left, you cannot join again and start at the same position that you left. You really cannot join again. That was all. When you left, that was all for you. Yeah. The change came. The change came when the Act number 19 in the year 47 came in force. That was an act that its name is very long, but it's really non-translatable, I think. But women now had to be counted as military salarists. That's somebody who serves in military and is paid by the military, and usually is either non-commissioned officer or commissioned officer or officer. So women should be treated as salarists and long-term service non-commissioned officers if they wanted voluntarily to join the army. So the only issue was that they had to apply for the job or for the position. It was not mandatory for them to join the army at any circumstances. This rather surprisingly was an issue for a lot of women, that the general duty to serve and duty to conscript was not applicable on them. For me, it's a surprise because really I don't know if it is a good idea to have more duties than you really need to have. We live in an age where really we do not want to have more duties. We want to have more rights. And these women that were not content with these arrangements under the Act number 19 from the year 1947, nevertheless fought for the ultimate equalization in rights and duties, especially, surprisingly, in duties. And what is more surprising is that their effort was led by Milada Horáková, the famous politician that was later executed by communists during the political trials of the 50s. Finally, this effort was crowned with a success. And in 1949, the bill was approved, and the act went into force in 1950. And the new military act defined military duty as two separate duties. That was the same as the former military act from 1920. The duty to serve was the first one, and the duty to be conscripted, conscription duty. And both these duties really applied on women at the time of alert defense readiness condition. So to simplify it, when Czechoslovakia was going to war, every woman could be conscripted. Now, the duties were in fact really much more similar to men than before, and duties also rights were in fact very similar under the effect of the 47 legal act, not legal act, just act. Otherwise, women could join military only after they voluntarily applied for the service or to join the army. So this brings me to the conclusion, and the conclusion is really what I've said numerous times. As I've read it, the materially. So, as to the content of duties and rights of women, they really were they really were equal as in rights to men already in 47. But formally and also materially regarding duties, not only rights but duties, they really were equal only after the enactment of the 49 or rather 1950 Military Act. It was some kind of a final step, some crown on the head of this effort. That's all from me for now. And if you have any questions, I will be probably able to answer them afterwards. I will try to join the Iustoria on my phone and probably try to answer them. So for now, thank you, man. Thank you very much.
Thank you very much for the presentation and that you were able to stay with us and present before rushing away. So thank you one more time. We have another change to this session. Unfortunately, another participant, Nikola Paunović, will not be able to join us. So I will now give word to the next present presenter, and that's Marie-Therese Mundsperger from Universität Wien, so University of Vienna Faculty of Law, and she will present her paper on the topic of women's suffrage in the Austrian monarchy from 1848 to 1918. Hello, Marie.
Hello. I'll now try to share my presentation.
That's right.
Okay, which one? Oh, I have to open it. Okay. Hopefully, I'm sorry. It's always difficult.
Don't worry.
So hopefully it should work now. Share. Yeah.
Okay.
See it now?
It's still loading, but it will show up in a minute, I guess. Ah, there it is. It's okay.
Okay, it's here?
Yeah.
Perfect.
Yes.
Okay, thanks for the invitation to the conference, and want to thank you for organizing this, that this could happen online if we are not able to come to Belgrade. Okay. As you see on the first picture, I'm talking about women's suffrage in the Austrian monarchy. On February 1919, which is now almost 100 years ago, women in Austria were able to take part in an election for the first time under universal and equal voting rights. The years 1918 and 1919 included a large number of anniversaries and memorial days in Austria. Thus, in 1918 ended not only the Habsburg monarchy, which had existed for centuries, but the Republic was also proclaimed on Austrian territory. In connection with this proclamation of the Republic, universal and equal voting rights were introduced for all citizens. But the struggle for women's rights started much earlier. However, the right to vote in Austrian monarchy already included women to a certain extent. After the failed bourgeois revolution of 1848, the right of political participation was defined by the principle of representing property and education. The right to vote was based on these two pillars and was retained in Austria at local and provincial level until the end of the monarchy in 1980, although it was slightly modified. Gender as a qualification criterion lagged behind wealth and education. Income and education defined who was allowed to vote and who was not. These preconditions excluded, on the one hand, many men from the right to vote who did not meet these conditions, but on the other hand, such a census suffrage included women who were able to meet the qualification as a matter of principle. As you see in this picture, the first level I start is the local level, the community level. The system of community suffrage that was established in Austria in 1849 after the revolution, and whose principles remained almost unchanged until the end of the monarchy, was a census and a three-class suffrage. Women were given the right to vote if they had the appropriate property or tax payments. The both genders granted active community suffrage regulated in the Provisional Community Law 1849 was a right to vote based on corresponding tax payments based on property or a business in the community, and could at first glance be accepted as political equality right for women. A closer look reveals, however, that women were not given the opportunity to become a visible part in the political area. This was achieved because women were not allowed to vote personally. This measure continued to exclude women from public service also. So it was mentioned in this law that women and also people who were minors or undercurate had to be represented by an authorized representative of their choice. In this regard, the community electoral regulations on the Austrian crown lands adopted in the 1860s consistently followed the guidelines drawn up in 1849. Important cities which had their own statutes, such as Vienna or Prague, women were not entitled to vote at all. However, the proportion of women in the electorate was not negligible. For example, in the Bohemian communities in the 1880s, they made around 20%, and in the city of Salzburg, another example, around the turn of the century, there were even more than a quarter of the eligible voters women. To a small extent, these women were represented in the second electoral body, but mostly as small traders or businesswomen or owners of small properties were able to vote in the third class. Equally controversial was the question of whether female teachers and university graduates were included in the so-called intellectual suffrage, i.e., if they had the right to vote without any tax payments. This group of the intellectual voters included members of certain professions such as priests, the military, the court and civil officials, and the teachers, as well as graduates from Austrian university with doctorate. The law did not provide a clear answer if this group could include women. However, it was not undisputable whether women could also belong to the class of intellectual voters. Both Austrian high courts of public law, on the one hand the Supreme Administrative Court, and on the other hand the Imperial Court, considered themselves competent to decide on electoral law, which is why judicature exists from both Supreme Courts on this specific question if women can be included in the group of the intelligence voters. For example, the Supreme Administrative Court has developed a line of judicature since the 1880s, according to which women, especially female teachers, are not entitled to vote due to the intellectual suffrage. In his first decision regarding to these questions, the right to vote for dead teachers was only available to male teachers, but not to female members of the teaching profession. One of the reasons for this was that the German male grammatical form teacher does not automatically include the female gender in the election regulations. In the following years, especially female teachers, but also female heads of monasteries, repeatedly tried to fight for the right to vote in court. The Supreme Administrative Court did not deviate from its previous view until the year of 1904, when he ruled that the term teacher meant all members of the teaching profession, regardless of their gender. If the legislator had only understood the male teachers, he would have had expressed this through an explicit addition. The court justified this change in his jurisdiction, among other things, by the fact that the required public employment and higher education are available to female teachers in the same way as to that of their male colleagues. In these circumstances, the preferred right to vote without any tax payment is justified. In the Crown land of Carniola, this changed jurisdiction was finally incorporated into the law in 1910. This consequently now spoke of male and female teachers. But the Imperial Court also considered itself competent to decide on questions of community suffrage, including the right for women to vote for women. From Moravia, 3 cases came to the Imperial Court regarding the right to vote in the intelligentsia class, whereby the lawsuit was dismissed in all 3 cases. The reasons for this decision was that the grammatically masculine form teacher and academic mentioned in the electoral regulations did not automatically include the female gender, and since the turn of the century, women have been able to study in Austria in the university, so that now the female academics also demanded the rights to vote. The court further held about this problem of female academics that it was a fundamental intention of the electoral regulations to restrict the right to vote for women, for example, by denying them the right to vote personnel. The other professions which were given the right to vote without any tax payment were clearly male professions, for example, namely the clergyman and the military personnel. The imperial court maintained its opinion despite the change in the jurisdiction of the Supreme Administrative Court and opposed the right to vote for women until its end in 1980. Now we're going on the next level, the land of the Austrian provinces. Here starts the right to vote after the end of the neo-absolutist system, which was caused by a financial crisis and the impending state bankruptcy at the beginning of the 1860s due to the lost war against Sardinia-Piedmont. This made it necessary to abandon the neo-absolutist system and to return to constitutionalism. One of these reforms, which were now taken, was the establishment of provincial diets in the Austrian crown lands, which were to be elected by the population, and which in turn were to send deputies to the Imperial Council, which should be the new state parliament in Vienna. The individual electoral regulations in the crown lands, which were regulated uniformly and literally almost identically in the February patent in 1861, were primarily intended to maintain the interests of the predominantly aristocratic large estate owners and the wealthier urban citizens. This was achieved through a so-called Curia election law, which divided the electorate in 4 different electoral classes. These were the large landowners, the chambers of commerce and industry, the cities and markets, and the rural communities. Every one of these electoral classes was assigned a certain number of mandates. Within the curias, the right to vote was tied to a specific census based on property and income tax, or, like on the community level, to educational requirements. The right to vote for the provincial diets remained due to the census prerequisite and the strong connection of the electoral regulations with the community suffrage in the curias of the cities and rural communities. According to the wording of the laws, it was gender neutral, i.e. women were also entitled to vote. Surprisingly, at the provincial diet level, the principle that women had to be represented when voting was broken, since it was determined that every vote, except in the curia of the large landowners, was generally only given personally. In legal practice, this provision about personal voting, which contradicted the community suffrage, inevitably created great confusion. In the absence of clear provisions, due to this uncertainty, practice in cities and the rural communities varied considerably, depending on the crown land, the district, or the time. For example, women were sometimes removed from the electoral roll, sometimes not. In some cases, women were not allowed to vote despite appearing on the electoral roll. Then they were sometimes allowed to vote personally, or sometimes not. In Lower Austria, for example, the provincial diet election of 1861 was criticized because women had voted personally. The provincial diet finally accepted all votes from women as valid. To clarify the legal situation of women voting, some crown lands implemented legislative amendments and the majority of which ruled that women had to be represented in all curias when voting. Not only the question of the personal voting, but also the regulation on the granting of powers of attorney for the elections remained controversial. For example, the legal term of power of attorney means that the holder of the power of attorney must carry out the wishes of the person who gave the power of attorney. In fact, women were often forced to transfer the right to vote to a man who could not be forced to vote according to the will or could not be controlled that he voted like the woman wanted it. Misuse with the power of attorney system was therefore open. The reason given for the frequent denial of personal voting rights for women was given, among other things, that the stormy course of an election would make the personal appearance of women unacceptable. This problem was taken into account in two crown lands, in Lower Austria and in Vorarlberg. From 1904 onwards, women in Lower Austria were generally allowed to vote personally, at least at the community elections. However, the wife of a man who was entitled to vote had to continue to be represented by her spouse, who was only allowed to cast one vote for himself and for his wife. The women were either explicitly excluded from passive suffrage, or their exclusion was taken for granted so that it was not even mentioned in their electoral regulations. Because of this, it could happen that women took advantage of this regulatory deficit to actually run for the provincial diet. For example, in 1908 in Bohemia, two women, Karla Mrázková and Marie Turmová, whereupon the eligibility was explicitly limited to men shortly thereafter. Now we are on the last step, the suffrage for the imperial court. Direct elections for the second chamber of the Austrian parliament, the House of Representatives, were only possible from 1873 onwards as part of a reform of the electoral law. The first chamber, the House of Lords, was only open to the nobility and personalities appointed by the emperor. Now they started the direct suffrage for the House of Representatives. They took the same regulations like on the provincial diet level, but in contrast to the gender-neutral formulations on the provincial diet, electoral regulations, the women at the imperial court elections were only allowed to vote in the curia of the large estates. In the further development of the electoral law, the gender-specific provisions of the parliamentary electoral law of 1873 served as role models for the provincial electoral regulations. Thus, from 1884 onwards, several crown lands started to exclude women from the right to vote. So this was the trend. In parallel to the development of pushing back or abolishing the existing rights to vote for women, the right to vote at the provincial and state levels was extended to even larger groups of the male population. First by reducing the tax requirements and then by introducing a general electoral class. The 1907 electoral law reform finally eliminated the curia system and gave men over the age of 24 universal and principally equal voting rights. The losers in these reforms, the intent of which was to democratize the electoral law, were women, since the reforms removed the modest approaches to women's suffrage at the level of the Imperial Council. Because of the elimination of the curia, also the women who were entitled to vote in the curia of the large landowners lost their right to vote. To put it bluntly, it can be said about this development that the increasing democratization of the right to vote was practically at the expense of the right to vote for women. Now we're making a big step to the year 1918 and the end of the monarchy. With the political upheavals and the overthrow of the monarchy in 1918, the way to the introduction of women's voting rights in Austria was finally paved. It was often argued that the achievements of women in the war caused such a revolution in public opinion that the right to vote for women could no longer be prevented. In fact, the legal breakthrough is primarily due to the new power potential of the social democracy and the relenting of the Christian Social Party, which hoped to gain votes. The first a big step, was on the 12th November 1980. The granting of women's voting rights to all representative bodies was finally linked here on this day to the proclamation of the Republic of Austria. Article 9 of the law on the form of the state and the government already stipulated that the electoral order, still to be decided, should be based on the general, equal, direct and secret right to vote of all citizens regardless of gender. The voting age was set at 20 years and the passive voting at 29 years. Principal opposition to the right to vote for women was rare at the various stages when the electoral regulations were issued for the Austrian Constituent Assembly. Rather, the focus of the discussions was on the possibility of subjecting female voters to control, since each party feared that the opponents would win the election, which was promoted by the right to vote for women. In addition to the proposal to use different colored ballot papers or envelopes or different ballot boxes to get information about the supposedly specific voting behavior of women, there were requests to limit the number of female voters who, as a result of the war, had more than the half of the possible voters. The Christian Socialists and the German National Party particularly stubbornly called for the introduction of a compulsory voting on the grounds that otherwise only radical or social democratic women would vote and hardly the conservative ones. These aforementioned attempts to manipulate the right to vote for women were not realized in 1918, apart from the exclusion from the right to vote for women who were under moral surveillance, which meant prostitutes, on which there was a consensus among the parties. However, the discriminatory provision was already abolished by the 1923 electoral regulation. The obligation to vote was left to the federal states legislation, and the gender-based vote counting was only introduced in 1920 and maintained throughout the First Republic. In the election to the Constituent Assembly on the 16th February 1919, women were able to exercise the newly acquired rights for the first time. With almost 52.2%, women made up the majority of the population who voted. This figure made clear that the women were thoroughly relevant as voters from the 1919 election onwards. On the 4th March of 1919, women were now for the first time able to go into the parliament. The first 8 female parliamentarians finally entered the parliament. In addition to 1 Christian social, there were 7 social democratic. So that was my representation, and I would thank you. And I hope that I catch the time, even if it was a little bit long. Thank you.
Thank you, Marie. Don't worry about the time because this session is a bit shorter than we anticipated, so you're not that much limited as maybe other participants. So again, thank you very much for the very interesting presentation. And now we move on to our next and, well, final presenter. We go back to Czech Republic, and we have Jakub Novák from Masaryk University Faculty of Law, and he will present his paper on the topic of Women of the Legion, Unrecognized Members of the First Czechoslovak Army. Okay, we have Jakub here.
Yes.
We see the presentation, it's functioning.
Great, thank you.
Continue.
So, thank you, ladies and gentlemen, dear colleagues. Let me shortly introduce you into the topic of my paper, That is the legal status of women which served in the Czechoslovak Legion in Russia during and after the First World War. Firstly, let's establish what actually were the Czechoslovak legions. At the beginning of the 20th century, the Czech lands and Slovakia were part of Austro-Hungarian Empire. These two nations were considered loyal to the empire up until the start of the World War. With the suppression of national rights, the Czechoslovak resistance movement in exile was established with its military branch that were the Czechoslovak legions. These units were established in 4 countries, in Russia, Serbia, France, and later also in Italy, and were made up entirely of volunteers, as this was considered better for the fighting morale and also for the propaganda purposes, as it would show the people in Entente countries that Czechs and Slovaks are willing to voluntarily fight for their independence against the Habsburg Empire. Originally, these units were formed entirely of Czech and Slovak immigrants, especially in France and Russia, but later as the war progressed, it was allowed by the Entente authorities to also recruit soldiers from prisoner camps, as great numbers of Czech and Slovak prisoners of war were in these camps and many of them were willing to join the resistance movement. These units, by their successes, especially on the Western and Eastern Front, ensured the recognition of independent Czechoslovakian state by the Entente powers, especially by France and Italy, later also by the USA. And after the war ended, the legion from France and Italy moved to Czechoslovakia to form the core of the new army and take part in the so-called Wars of Integrity, which were wars with Hungary and Poland for establishing the borders of the new countries. The Russian Legion, however, wasn't able to get home in time, as they were involuntarily caught in the Russian Civil War. And this is the part important for the topic of this whole paper. On this interwar poster, I hope you see it, we can see the numbers of legionnaires in each country. These 4, the 4 on the right, are the really legions. Those were independent Czechoslovak units within armies of these countries. The 2 on the left, the USA and Great Britain, in these countries, Czechoslovaks were integrated into their own armies and thus were not considered Czechoslovak legionnaires. After the war, an important question arose. Should we somehow reward these fighters for independence? The simple answer was yes, we should, and let's say by some benefits in form of money and in form of better employment. But how do we recognize legally who is and who is not a legionnaire? So there were issued 2 laws. The first was the Act number 462 from the year 1919, and later government regulation number 151 from the year 1920. These laws showed the 3 main conditions for being recognized as a legionnaire. The first was pretty simple. Enlistment into legions before the 20th October 1918, which is the date when the independent Czechoslovakia was established in Prague. You had to also to serve until this date or to be honorably discharged or logically die before this date. In both these cases, you would be also considered a legionnaire. And thirdly, you had to enlist immediately, unconditionally, to serve wielding a weapon. That is important. Remember this, as this is the most important condition for the rest of this paper. There were also 2 exceptions. Either if the soldier did not serve until the 28th of October 1918 because of reasons beyond his means. That means usually it was the case when the legionnaire or the soldier applied to join the legion, but the bureaucracy was too slow to allow him to do so in time. Or he did not serve with a weapon, but in a service marked as comparable by Czechoslovak National Council. These were usually doctors, politicians, agitators, and so on, who did not join the military branch, but their help was considered so great that they were also allowed to receive status of a legionnaire. Now, for the most important part, I expect want to hear. Women in the Czechoslovak legions in Russia, as the other legions never got into a situation as desperate as the legion in Russia, and so did not have to use women as an auxiliary force. Theoretically, as the legion was organized mostly like the French army, it was impossible for them to apply to join directly the army. So they joined the auxiliary positions, especially as merciful sisters. That would be today's nurse. These were not, of course, only Czechs, but especially, if the legion took part in the war, in the civil war in Russia, there were Japanese, Americans, Russians, Chinese, and so on. So many nationalities. And they were not officially considered part of the army. They were serving only with the army. Aside from that, we have several exceptions I was able to find in the archives. These unusual cases were usually couriers, spies, reconnaissance members, and etc. After these women returned from Russia, they were considered not as important as the legionnaires. They were sidelined. And that was mostly because it was considered that they did not really fight. Even though they served on the front line, even though they served with the soldiers, it was said that they did not apply to serve with a weapon, and thus there is no reason or no legal reason to allow them to have the status of a legionnaire and the benefits connected to it. To demonstrate this, I will show several cases so you can imagine more in detail. Here you can see a picture taken from one of the files of these women. If you look at it, it's in Czech, so I'll translate. This handwritten part says, "is not legionnaire according to the Act number 462 from the year 1919. Every one of files of these women was actually investigated by the officials back in Czechoslovakia, and each of them individually was marked not a legionnaire according to law because of the lack of service with a weapon. It was explicitly said that they did not serve with a weapon." So, those specific cases I've mentioned before. Firstly, we have here merciful sister Aneška Kašparová. That is the most common case. I can demonstrate on this how it worked in praxis. She joined in the beginning of the year 1918. She left the legion at the end of that year. So she fulfilled the need to serve around the date of 28th of October 1918. She also served with the soldiers. She served on the front line, but she applied as a merciful sister, so she never held a weapon. And thus, in her file, we can find these words: "She is not a legionnaire because of the lack of service with a weapon." Simple. Božena Sajlová is much more complicated situation. Since she did not serve as a merciful sister, but instead she was a reconnaissance member and with it also a courier. She was a member of Czech community in Moldova, and in her 18 years, in the year 1918, she volunteered to move to Siberia to contact the Czechoslovak Legion and deliver a message from the Czechs in Moldova. She was able to do so in several months. Then, after several days, she turned around and delivered a message from Siberia back to Moldova. Then she received another message and walked other way around. So she crossed the front line 3 times. The legionnaires in their diaries call her a sister. That is very important, as the legionnaires, as a voluntary army, did not use to call each other by military ranks, even though they had them. They did not use them amongst themselves and called each other of them brother. If they called someone a sister, that was like if they considered her a member of their social group. Even though this was true, even though she was considered as a legionnaire by the legionnaires, when she returned to Czechoslovakia, when she came to Czechoslovakia, the status of a legionnaire was also denied to her because she never served with a weapon, or at least she never volunteered to it. The legally most interesting case is Rifleman Merciful Sister Vera Gatti. This case is interesting because of this. She was a Russian student of history. She applied to join the Czechoslovak 1st Rifleman Regiment, but as the leader of this regiment, as the commander, was not able to recruit Merciful Sisters, and he had not time to wait for her to be recruited because he needed nurses in his unit. He did it in some way, specific way, and he recruited her as a soldier. She received military rank of rifleman, that would be today's private. She received uniform, but she served as a merciful sister. Even though she later left the Legion at the end of the year 1918 and stayed in Russia, when the legionnaires came back to Czechoslovakia and her file came with them, the officials were not able to find a reason not to give her a status of a legionnaire, because theoretically she applied to serve with a weapon. She did not in the end, but the fact is that she applied to do so, and thus she should receive the status of a legionnaire. And since they were not able to find any reason not to do so, she actually is the only known female legionnaire in our army. Through this, she never came to Czechoslovakia, so she never enjoyed the benefits. But from the legal point of view, we know that it was possible actually for women to be a legionnaire if they somehow fulfilled these very hard for them to fulfill conditions. So in conclusion, I was able to identify the conditions for a person to receive a status of a legionnaire. So that means member of the first Czechoslovak military resistance. I was also able to find out why women usually did not receive this status, but also find a case that is exclusion from this. So I'm hoping in future I will be able to study more of the files and hopefully find another such cases to see if one of them was able to come back to Czechoslovakia and actually enjoy the benefits, to see how these were in reality fulfilled for women. So I thank you for your attention, and I'll be looking forward to any questions.
Thank you, Jakub, for your presentation. So, well, you were our last presenter, so I'm opening discussion. If there are any questions, comments, anything, hands raised. No. Okay, I have maybe just a general comment on the topic that Marie presented. It's really not a question, it's just maybe a comment. Because I'm a language enthusiast, and it was very interesting to me to see how language can directly be used as an obstacle for women to achieve their rights. That part where only male form of a profession was used to enable women to vote as well, the male teacher, female teacher that you explained, the Lehrer, as it said only in the law. If someone was benevolent, he would interpret it both as male and female teachers, but because patriarchal society was the interpreter, it was interpreted as only male teachers. That was quite interesting to me. It seems that at that point, women kind of realized that it was necessary to create female forms of professions and introduce them to law. in order to have access to same rights as men. It's just a comment. I mean, it's not a question in any way. So that was interesting. Any other questions? No. As for the topic of women in the army, again, just a slight comment. I didn't know much about women in Czechoslovak army, of course. So, but what I understood is that women in army really had issues in gaining any kind of recognition. That's universal. I think also in Serbian army there were issues for women to gain any kind of recognition. Nina may correct me maybe, but I think our famous female fighter Milunka Savić, I mean, she did get some kind of recognition, but at the end, when the war passed, I mean, she worked as a cleaning lady and she was at the brink of poverty, completely like forgotten. So yeah, that was interesting. Any other questions?
Excuse me? I just read there was a question for me in the chat. So
Great.
maybe I can answer it. So the question was what arguments were given for the abolishment of female suffrage. Well, what has to be said, there were different argumentations in the Crown lands, but one of them was that women were too weak to vote, and it has to be a male thing, something. And another one was all the electoral regulations had to be uniform. They had to be the same in all the Crown lands, and the easiest way to make them the same was just to abolish the right to vote for women, then it's equal for all the women. And there's no inequality. And one of the last one was that they started to democratize the right to vote and to open it to more and more spaces for men, like to reduce the tax payment. And with this, they also said the women were just allowed to vote because of the tax payments, then they were equal. And if you say it's the same, equal suffrage for all the men, then there's no space anymore for the right to vote for women based on the tax payment. Then they lost it. So I hope maybe I made this a little bit clear, hopefully. Maybe if you can just write in the chat if this was enough, or shall I talk more about it?
It was, I think, enough. So there is another question from Nina, directed, well, to Vojtěch and Jakub, but of course other people can participate as well. So the question says, military service is usually not as frequently mentioned in the fight for gender equality. Do you think that women should have to serve in the army like men? So I'm not talking about volunteers, but mandatory service.
Well, from my point of view, if we are talking about equality and equalization, then the citizenship and the rights coming with citizenship should be coming also with some obligations for the country or for the state that you are a citizen of. So the fact that you are receiving all the rights, which should be standard, should also come with the fact that you receive all the obligations that come with it for all genders. Oh, I would put that as simply as possible. If you want me to talk about it more, I think I would be able to do so for a few hours.
Okay. So do you hear me? Can you hear me now?
Yes, we do.
Yes, we can hear you. Don't worry.
Okay. Only a short answer. I'm here in the hallway, so the main problem is the purpose of an army. We live in fabulous times when the army's main purpose is not to fight for some ideas like an independent state or freedom of a nation, But the main purpose of the army nowadays is probably to help in a situation where nobody else can help. And nowadays, in fact, we do not have the duty to serve for the standard duty to serve for at least I don't know, a year or 2 years, like in Israel. Here in Czech Republic, so really we are not as familiar with the army and military at all. And problem is if we do really need somebody to serve in the army and they are not volunteers, so there is a period of time served for example, a year or 2 that is mandatory for everyone, probably to equalize the duties and the rights, it's good to narrow the gap between sexes, to apply those rules to everyone. But me, myself, I really do not think that any woman should be forced to serve in the army, as well as I don't think that any man, if it is not necessary for the defense of the state or some really grave issue, should not be mandatory forced to serve in the army. But of course, when there are dire times, bad times, men should be first ones to go into this battlefield of swords and to to sort out the situation. And I think that women should really play some. I don't want to say. I'd like to say a support role, but I don't. I know many women that it should be probably better sharpshooter than I am myself. So this is a question of feelings and not facts, and I really don't know if I can answer it better than this way. So that's all.
Thank you for getting back to the discussion and for your answer. Is there maybe anyone else who would like to add a comment to this question? My participant disappeared. Okay. So, no one else? Okay, so let me read what Nina said. Thank you both. If any female participants have an opinion on it, I'd like to hear it as well. So any girls here that would like to add their opinion on the women in the army? No? Our girls are shy? Well, I guess if we don't have any more questions, we could wrap up the discussion part and move on to our break. So thank you again one more time to everyone who presented today. Very interesting presentations. So we continue at this according to the schedule. So we start at 3:15. It's a Serbian session, session in Serbian language. So who wants to stay, he can stay and listen. And until that time, we'll just take a break. Okay. Bye.
If I may,
yes,
just a quick question. After the Serbian part, will there be some closing of the conference where even the English-speaking attendees should be?
Now, can you write because I'm not sure if anyone will close anything special in English. Let me just wait for the answer in the chat from Nina. We can speak in English if you come, but you don't have to. So that's kind of it's more just like a formal bye-bye, not any particular introductions or lessons or lectures, etc.
Okay, then I guess goodbye, and I hope I'll have a chance to meet you again, hopefully in person next time.
Hopefully in person for the next conference in March.
Hopefully. So goodbye.
Bye. Thank you. Thank all of our foreign participants.
Also, thank you for me. Thank you that I was able to speak here. Thank you. Bye.
Thank you. Bye.
Thank you.
Thank you. Thank you.